Hello, this is Dan Marr from Hamlin Kerrigan in Nashua, New Hampshire. I've been practicing for over 35 years. I'm licensed and practice in both New Hampshire and Massachusetts. And today I'm going to be talking about in this vlog briefly about what we often call in lawyers as boilerplate provisions in a contract. Provisions that seem at the end of the contract to be fairly innocuous, but they aren't. And they can have some serious consequences as to your relationship. So we're going to be talking about that today. I'm going to start off with the first one, and again, I've been doing this type of work for decades, and I've dealt with these both in to transactional of putting them into contracts and negotiating contracts to successful conclusion and litigating these matters. So when there's a contract that's out there that somebody else has done and there's a fight and I'm representing one of the sides dealing with these issues. First issue I want to talk about is the choice of how to resolve this without going to court. There's a provision that may have a provision that says you're first going to go to mediation and then you're going to go to arbitration before you and you don't go to court. Mediation can be a very wonderful option. I think it's a good choice if people can't negotiate something, but sometimes you might have a timeliness issue where you need to move quick. And if, by way of example, if you have a partnership agreement with some partners and one of your partners you think is embezzling monies, you don't want to go through mediation first to say, hey, stop stealing my money, nor do you want to then go through arbitration, particularly if that person, and I've seen this recently, where they didn't know this ahead of time, but the person is really, the other side is really a bully. And it's wonderful to have that person in court saying bad things and acting like a bully in front of a judge rather than in an arbitrator circumstance. So in that situation, it was a lot better that I was able to get around or move around an arbitration provision because of some bad acts that the person did and get in front of the judge so we could deal with those issues. But an arbitration provision, you're in between, you're with an arbitrator, you don't have a judge that has the contempt powers of the court to do something if the person's doing something wrong. So that's something to consider. But again, if you think that that's the type of person you're going to be getting into a relationship, don't get into the relationship, of course. But arbitration, sometimes you need to move quick on something and you might have to step out of arbitration. I've had situations where I've moved to stay arbitration or done other actions to get into court, because if you're trying to get a judicial lien, you can go to court first generally. If you need to get what's called an injunction, a court order saying stop doing this stuff, you can go into court for this. So there's a variety of options that you can deal with that, but consider that when you're dealing with arbitration. Also, with an arbitration, you want to find out what the process is. You want to certainly understand is if somebody's saying a 3-panel arbitrator, it might be more expensive than going to court. Even though courts may take longer, a 3-person arbitration panel is going to be expensive because you're paying for 3 experts that are probably going to be charging hundreds of dollars an hour, probably anywhere from $400 to $500 an hour perhaps each, and it's going to be expensive. So consider that. Another issue that's in boilerplates is attorney's fee provisions. If there's an attorney fee provision that says one side gets the attorney's fees and the other doesn't, I certainly put that in if I'm representing one side, and if I can get that, that's good. Generally, if I have the more bargaining power, like I represent a landlord, and certainly banks have those provisions in for lenders. But consider that issue if you're dealing with a true equal bargaining power situation. And also consider if it says prevailing parties on the attorney's fees, if there's a rich guy and a poor guy, a rich gal and a poor gal, in that situation, the person that has more money can afford to take the risk of a prevailing attorney fee provision, because them writing a check for $100,000 may not be that big if there's attorney's fees, but they can absolutely scare the other side into submission with that prevailing party attorney fee provision. So if it's a gray area that you want to deal with, you're the one that doesn't have the money, it's going to be enough to probably burden them into not challenging what the other person is doing. So consider that as a shifting of the bargaining powers, prevailing attorney's fees provisions. And you can talk to me about that if that comes up in a negotiation. Choice of law. If you're dealing with a New Hampshire business and you're dealing with New Hampshire property and people are located in New Hampshire, obviously New Hampshire is the appropriate place. I've seen provisions where somebody has a a lawyer that's in California and they say that California will be the law that applies because their lawyer happens to be there, even though no one else is there. Be careful about those and don't agree to those things right off the bat. And that's something that's a negotiation ploy if you have equal bargaining power. In some consumer contracts, I've seen a non-disparagement provision saying that no one's going to be disparaging each other you're not going to disparage the other side in social media. Be careful about that. If they actually put that in there, they're basically saying when you're looking for customer reviews of this customer, everyone else is scared of going forward with providing a negative review because they got a contract that says they can't. So when they've had a bad experience, you're not seeing that in the internet, and that's a lot of times when you're reviewing things to see what customer reviews are. If you actually have that as a provision in the contract that's being presented to you, I would suggest run from that company. If they have that type of provision that says a consumer contract that says you're prohibited from disparaging or saying anything negative comments to us on social media, run from that company because you're not seeing all the bad reviews that might be out there because they're contractually obligated not to provide the bad reviews. So that's the gist of these contract provisions. If you have any questions in negotiating a contract, you can contact me at Hamlin Kerrigan at 603-883-5501. That's 603-883-5501. Or check out our website at NashvilleLaw.com. That's NashvilleLaw.com. Look forward to talking to you if the opportunity arises. Thank you. Bye-bye.